Professor Smith, welcome to Constituting America's Constitutional Chats. We're hoping you could just give us a brief overview of the First Amendment, and then we'll go from there with some questions.
Okay, well, thank you, Kathy, and I thank everybody for joining us. And it's a treat to learn just now that the episode is being sponsored by my friend Patrick Gary, who's a fabulous writer, and people need to pick up his books if they have not done so. So today,
Professor Smith, sorry to interrupt. I think there's something over your camera. Oh, there you go.
Okay.
We couldn't see you when that was over your camera.
Oh, well, that's not good. Okay. Well, today we're going to talk about the First Amendment. And the First Amendment basically comprises really 6 different rights: freedom of speech, freedom of the press, freedom of assembly, and freedom or the right to petition for the redress of grievances, plus the 2 religious rights, which, as Kathy mentioned, are going to be taken up in another episode: the opposition to the established church and the right to practice religion. So we're going to talk about the first 4 of those. Now, I was going to assume that everybody kind of knows what free speech is, right? It's the right to speak our mind, to say what we want to say, and that's something that people feel like we can do. But let's talk about the other rights that come that often don't get too much attention when people talk about the First Amendment. So first up is you have the right to freedom of the press. Now, freedom of the press is not, contrary to what some people, mainly practicing journalists, tend to think, it is not a special right that belongs only to journalists or publishers, newspaper reporters. It's not restricted to people who are eligible for membership in the National Press Club. It's a right that all of us have, and it's a complement to the right to freedom of speech. That is, it is a right to publish our ideas, to put them into books and magazines and pamphlets, and in the modern day, to put them into blogs and DVDs that we can create in creative YouTube videos and so on. So today, almost all scholars agree that press in the First Amendment refers to a technology, that is the act of publishing or an activity, and not to a particular group of people. Everybody has the First Amendment, right? It belongs to all of us. Practically speaking, again, this allows us to do all kinds of things that nowadays would have been very tough in the past, like self-published books, much easier, or self-published DVDs. People create amazingly good movies that are published on the web or on DVDs still. You can do YouTube videos. So think of all the ways in which that right to press benefits you. It's not just freedom of speech. We sometimes tend to think of it as just all freedom of speech, but really you can break it down and see how important that is. Secondly, we have the right to petition for the redress of grievances. I take them a little bit out of order here, but this is one of my favorites because, again, a lot of people don't really, what exactly does this even mean? Well, in the 18th century, the right to petition was taken quite literally. That is to say, one of the common forms for the citizenry to make its views known to representatives in an era when travel was difficult and you didn't have, phones, and certainly didn't have the internet and so on, was to draft petitions and gather signatures on the petition and have somebody take it to the authorities or to the legislature, asking them to act on a particular problem. This right, like a great many of the rights that eventually appeared in our U.S. Constitution, traces its history all the way back to the Magna Carta of 1215, when the King John agreed that to allow people to make request of the king through their barons at the time. You still had to go through the baron, but it was a start. This right was later adopted in the English Declaration of Rights of 1689. And what the right meant really was that if you signed such a petition, you couldn't be punished for it. That is, the king couldn't say, oh, I see who's signing this petition. These guys are troublemakers. Go out and arrest them, go out and harass them, go out and confiscate their property or whatever else it was. So signing a petition was a protected activity. We don't often think about the right to petition because we kind of roll it all into this idea of speech. But it's really important to think about it as a separate aspect of our right to communicate and to govern ourselves. It gives us the right to approach members of government without fear of reprisal. It gives us the right to lobby. People often say, oh, we hate lobbyists, special interests, and so on. But if you think about it, that's a badly needed right. If we can't go and petition our government, if we can't go to the government and say, here's what we would like done, what is left for us to do? I mean, we can either wait for the next election when no one may hear us, right? They may not pay any attention to what we want to do, or we're left to violence. And that doesn't seem like a very good alternative. So, bear in mind, again, the right to petition is listed separately in the Constitution, in part to make clear that it is protected. And secondly, it reinforces that core right to political speech, as does the right to the free press. And that takes us to the fourth of the speech rights, which is the right to peaceably assemble. Note that it is first the right to peaceably assemble. It's not the right to engage in violent protests. And indeed, if you think about it, the right to speak, to petition, and to peaceably assemble and to publish are all aimed at assuring that we have a way of communicating our views to government and providing for peaceful change and responsiveness to the people, short of resulting to some type of violence. The right to speak would, of course, be much less valuable if people could not also assemble to hear. And of course, this was especially true before you had, Zoom and the web and things like that. People had to kind of gather together to hear a speaker. But even today, that's obviously an important part of things. So it's kind of interesting that in 1670, William Penn was arrested while speaking on Grace Church Street in London for giving a sermon to a group of Quakers in the street in front of the church. The London officials had locked the hall and forbidden him to speak, to, quote, preach in any building. So he went outside on the streets and crowds began to gather, and they locked him up for having the crowds gather. And you can see what's going on here. I mean, the public, I guess you could say, were willing to let Penn speak if he wanted to go home and babble to the walls or to his family, but they didn't want him actually communicating to the public. Later, a few years, about a decade later, Penn came to the United States, was a founder of the colony called Pennsylvania. And it's not surprising, really, that the Pennsylvania state constitution was the first state constitution to include a right to peaceably assemble. And it's worth noting, by the way, just kind of as an aside, that many of the rights in our Constitution were based on things that Americans were already experimenting with in their state constitutions that were drafted between about 1775, when the Revolution began, and 1789, when Congress was meeting and talking about a Bill of Rights. So you see that all these rights, speech, press, petition, assembly, we all lump them together today as a right to free speech, but really they have separate purposes that are mutually reinforcing. It's kind of okay that we want to lump it all together as free speech, that's easy, but we should remember all the various dynamics that are involved and how important all of those are. And the intent is to assure that Americans will always have broad liberty to criticize our government, to advocate change in government or change in policies, just to speak your mind as part of your personal autonomy, and to voice our opinions and peaceably seek change. So just a couple of concluding thoughts. Of course, one of the great things about the First Amendment is that it helped imbue in our culture, our broader culture, and appreciation for free speech. The First Amendment, by its own terms, applies to government, right? Congress shall make no law. And later, through the post-Civil War amendments to the 14th Amendment, that is applied to the states, that states can't make laws abridging the right to freedom of speech. But it does go beyond that to create, I think, a culture in which Americans have historically, at least, been willing to tolerate speech, to listen to things that they don't necessarily like, not to try to shout people down and prevent people from talking and voicing their opinions. And I think this is one of the major reasons that the U.S. has been so dynamic and successful as a nation. If you can't hear new ideas, it's very hard to progress and to advance. And so this culture of free speech has been a real benefit for the United States. Unfortunately, today, it seems like not just the First Amendment, but this entire culture of free speech is sometimes under attack. Obviously, there are limits to freedom of speech. There's little reason to think that the framers or the public at the time thought that the First Amendment overrode, for example, traditional claims to libel and defamation. But most of the things that people argue about today, such as suggesting that the First Amendment doesn't protect some vague category of something called hate speech or disinformation, another vaguely defined category, have really these kinds of things run directly counter to the purpose of the First Amendment, and were not the kind of thing the framers had in mind when they wrote the First Amendment as anything that would be an exception that Congress or states eventually could prohibit. Others make the bizarre claim that speech is violence, or the claim that speech is a tool of the powerful, when in fact, of course, speech has always been a tool of the dispossessed, of the. Well, in a letter to George Washington in 1792, Thomas Jefferson wrote of freedom of speech in the press. He wrote, "Nature has given to man no other means of sifting out the truth in either religion, law, or politics." And that's really true. The ability to speak and to talk through our differences is how we learn and how we discover truth and how we advance. And so I shudder to think what would happen if we were to abandon our traditional understandings of free speech. With that, I'm happy to open it up. I love to take questions, so let's go there.
Well, thank you. That was a great overview of the First Amendment. And I have never thought before of freedom of the press, including all of the elements that you pointed out. And that's so true these days. The press has changed so much from the time of our founders, although I guess even at the time of the founders, people independently printed out pamphlets and distributed them. But that's a really great point. So I'm going to turn it over to Jewel and Jorn and let y'all ask a few questions.
All right. Well, that was definitely a great overview, and love to start asking some questions of where to start. So first of all, you can see how it follows as you went through from the free speech, freedom of press, until it concluded with the assembly, that the founders were protecting the way that we were going to use our speech. That it was not just going to be that it was going to be speech protected, but like you gave that example of William Penn, sure, maybe he had the right to talk to his walls, but he didn't have the right to then give that sermon. But here in America, you had the right to, they protected your right to put it into press. What you said about the distinction of press also thought, I don't know if I've ever heard it explained so quickly or simply for that either. It's the ability to put that speech into today, maybe a blogger or a YouTube video, and share that, proliferate that information. Do you think that, well, first you can answer that part of it, and then I'll ask a question.
Well, I think as Kathy pointed out, going way back, people would publish pamphlets and so on. You could always do that, but one of the great things is modern technology does provide a lot of ways for more of us to participate. And, it would be a really strange world where if, say, a large, influential, powerful corporation like the New York Times was protected, but small individuals who just want to put up a blog or something like that, or do a podcast, were not protected. That would seem like a strange power imbalance, we might say. And I think it shows again how, in fact, the First Amendment generally has been a tool that has most benefit those who don't already have power.
I know our founders didn't equate totally liberty and this idea of maybe you could say licentiousness. That freedom was not just the ability to do anything. So can you talk about how we have laws, though, where you can't, like you said, there's slander, defamation, libel. You can't yell fire in a crowded auditorium if it's a lie. Can you talk a bit about that and try to marry this concept that yes, we have freedom of speech, but there are limits to that freedom and what is freedom?
Sure. Well, I'm glad, Jewel, that you had it when you gave the example of shining fire in a crowded theater. You added, if it's a lie, which is something people often kind of forget to add. In fact, if it's true, it's actually encouraged. People would like you to go ahead and yell fire in a crowded theater. So, there are limits, and historically, what are those? Well, one is that category of defamation and libel. That's an old tort, goes deep into the common law, long before our own Constitution. And I think the notion there, remember that it's not easy to prove a libel case, and it's especially difficult to prove a libel case against a public figure. In the United States, under New York Times versus Sullivan, a case which is now about 60 years old, a public figure has a very difficult time showing that he's been liable. He's got to show by clear and convincing evidence that it was false or a reckless disregard for the truth. And it's very hard to do. And the reason the court has drawn that tough line is to make sure that people are not intimidated from criticizing public officials, that's in a way where the First Amendment right is most valuable. And the First Amendment right, by the way, I've kind of intimated about politics, but it's also valuable for culture, for being able to do plays and stories and all kinds of things that move people in other ways that are not directly related to politics. But at the same time, the Supreme Court has often suggested that at the core of the First Amendment is that ability to engage in political discussion and to talk about our form of government and our self-government. And so it's hard to prove that liable against a public figure, but even there, it's a traditional, old, well-established tort that is different from, I think, the notion of the government simply censoring views that it doesn't like. And of course, it's a private tort. Similarly, one area where the court has allowed some limitations on speech is the idea of obscenity. Where it's viewed that the speech has so little social value that it can be limited, regulated by government. But again, that's a pretty narrow exception, really. One only has to go, I suppose, into our modern culture to know that that's the case. And the reason that's protected to the extent it is largely because of the belief that we want to protect less valuable speech in order to keep government from using that as an excuse to start chipping away gradually at more and more valuable speech, right? So we kind of throw up a barrier that includes a lot of speech that maybe is of very little social value, such as certain things that people might view as obscene, but that have not been held to be obscene by the courts. Other types of examples along those lines would be, for example, incitement to riot. That can be limited, but note again, it's a very narrow category. Somebody has to be saying something that is likely to directly lead to a riot. It's under a case called Brandenburg versus Ohio. So it's not just, suggesting generally that we need to change our government or even saying it with something violent if it's not likely to immediately lead to some type of riot. Also, there's a category known as fighting words. But again, fighting words under a case called Chaplinsky versus New Hampshire is such a narrow category that you just never see prosecutions for it. Basically, it involves somebody, essentially getting to the point where, you can't, get at somebody and scream at them in such a way that it's intended to provoke and likely to provoke a violent reaction. But note that all of these exceptions are very, very narrow. None of them cut at more than the faintest margins of speech. And I think that's one of the most important things to consider. We've never kind of let these exceptions start to swallow the rule. So that's a great question that you asked and a great point. And yeah, we do have limits, but for the most part, we err on protecting speech rather than err on limiting too much speech.
And that is, there's so much on this topic that I think is important for today. So trying to limit the questions so we can get to Jorn, but putting some of the questions together, at what point, so we know that after that in more of the modern era, the 14th Amendment was applied so as that the Bill of Rights began to also, that the states as well were subject to the Bill of Rights, or that the state could not infringe on an individual's rights that was enshrined in the Bill of Rights, and that was applied. I think our last guest had said that it was from the 14th Amendment after the Civil War, but it was in a case maybe around the 40s. I'm not exactly sure, but it was a little bit later. But what about when we are in today we hear a lot of fear from people speaking their mind at work. There are many stories of people being fired from their jobs. There's plenty of people who were fired because the people found out they voted for Trump. It's kind of happens all the time. And I know that originally in our republic, an employer may have the right to do that, because it's their private business. But in modern times, the claim is that there's a violation of freedom of speech. Can you talk about that somehow, parse that out? How is it supposed to apply?
Sure. Well, as I noted, and as I think you well know, I mean, the First Amendment by its terms applies to government. Congress shall make no law, or as you pointed out, the states after the 14th Amendment incorporating the First Amendment against the states. So that goes to the government not making laws. Private employers traditionally have a right to make decisions along those lines. Now, I do think, as I indicated in my opening remarks, that we're losing the culture of speech. We're losing the idea of free speech, the idea that we ought to just, it doesn't really harm you. People today all the time say this, oh, this harms, this is violence, speech makes me unsafe. No, it doesn't. That's the very purpose. I mean, harsh words can hurt somebody. They can bother you for a time, but they don't physically hurt you. They don't pickpocket. Or take your money from you. And we used to let those things kind of roll off us a little bit more than we do now. Sometimes I hear people today, they'll say, well, you have a right to say what you want, but you have to be held accountable for your speech. And I always point out, no, the entire purpose of the First Amendment is that you're not accountable for your speech. In other words, not at least in the way they're talking, the government doesn't go in and say, well, you have a right to say whatever you want, but then we can hold you accountable and throw you in jail, right? I mean, that's, you can't do that. Well, I think the same principle should sort of apply in our private lives. We need to get used to the idea that we're going to disagree with people. Now, if you disagree with somebody too much or they espouse views you find abhorrent, you may not want them to be your friend. There may be cases where it's enough that if you're an employer, you want to fire them from the job if they're just disruptive or whatever. But all of this requires a certain moderation where we're willing to accept that people have different views, and that's fine. That's good. That's part of the spice of life and what makes life interesting. And again, it's one of the ways we learn. So there are some states that have passed laws that restrict the ability to terminate someone's employment based on their political views. One could view that as upsetting traditional notions of property rights. On the other hand, we've done that for a long time. And it's worth noting that we do require employers to speak or allow speech in certain other areas. Sometimes they're required to allow certain speech relating to unions on their property and a union organizing drive. They're required to put up certain notices in the workplace about, workers' rights, things they might rather not do. An employer can't sort of de facto discriminate against somebody on the basis of race or religion or sex by, saying, I'm required by law to hire you, but I really don't want to, so I hope you don't apply, right? You can't say that. That is considered itself a discriminatory practice against those kinds of groups. So we do have some limits there. It becomes a bit of a political question. And I think, to me, the much more preferable alternative would be that we just begin to recognize again that free speech is important and something that benefits us in our private lives. And it's not only government that
I do think that
right?
It's kind of funny with the one thing you just said, though, is that we do have freedom of speech, let's say, but then the employer can't say that. Can't say, hey, I really don't want you to work here because we're too different. Possibly they can't say that before that person may come to the interview. Could you just comment on that quickly? Do you think those two things contradict at all?
Well, I mean, again, the way one might think about it would be, what are the protected categories, right? It has to be a protected category. And we have protected categories, again, for race, sex, religion, national origin. In most places, and now sex has been interpreted by the Supreme Court in many circumstances to include sexual orientation. Those begin with race and the Civil Rights Act of 1964. And I think that's aimed at a very specific problem of long-term standing where a particular burden was placed on a group of people. And so it's aimed to put an end to that. And the prohibition on discrimination in hiring would lose a lot of its force if the employer could just put out there and say, okay, well, we have to hire you, but we really don't want to. We're not going to treat you very well. That also falls within that ambit of what the employer can and cannot do. To me, the important thing, though, is that we should be careful about letting that paradigm start to overrun all of our interactions. Historically, we've gotten a lot of freedom from the recognition of property rights, and people can do different things with their property. We overrode that in the Civil Rights Act again because of very specific circumstances, and I think entirely merited circumstances. But I do think that we shouldn't assume that is the template that we can then apply to anything we don't like in society. I think that would be a mistake.
All right, Jordan, ask away.
Well, thank you for what you've given us so far. So just to make sure, so can the states put any other stipulations on our First Amendment, and have any tried to make, and if not, have any tried to make that possible?
Well, there are other kinds of things that states sometimes try to do. And again, they'll try to do these often by claiming they're regulating conduct. And you can regulate conduct. For example, in a famous case, the Supreme Court upheld the right of the federal government to say you can't burn your draft card. And people were burning draft cards back in the 60s as a protest against the Vietnam War. And the argument was the government didn't really care if you protested the war. They just wanted you to have your draft card with you so that they could implement the draft properly, which they had a constitutional right to do. But conduct, you can't use conduct as an excuse to just go after speech. For example, in the area of campaign finance, which is near and dear to my heart, where I've done much of my scholarly work, sometimes people will say, well, we're not going to limit a candidate's ability to speak. We're just going to limit their ability to raise and spend money. Well, now think about this. If you can't spend money, the reach of your speech is dramatically cut back. If you can't spend money to rent a hall or to buy a TV ad or to, have computers and set up a Zoom connection as we have here today, or whatever, all those things require you to spend money. And so the Supreme Court has severely restricted the ability of states to impose campaign finance restrictions. Not as much as I personally think they should, but nonetheless, it's much more than a lot of people want. So states do try to regulate what we might call speech activities, usually under the guise of regulating someone's conduct. But I think we should be skeptical when states make broad claims in that area. Make sure, is it really the conduct you're after? Do you have some independent reason to stop that conduct? For example, they might, like if there's limits on protesting in front of a person's private residence, or if you have to get a parade permit in order to parade, as long as the state doesn't unreasonably deny parade permits, it's okay for them to ask for parade permit because they got to make arrangements for traffic and police security and all that kind of thing. But we have to be skeptical of broad claims when somebody makes that we're just regulating your conduct and not your speech, because often what they're really trying to do is suppress the expression of the ideas.
So when the amendments were written, there was obviously a very different style of speech. Our speech was at a much higher level. I'm wondering, how much do you think our change in speech, if any, has affected what those that wrote the amendment, what they thought it would impact, I guess? Because there's such a different way of attacking someone with words. It seems like it used to be more of a outwitting rather than a assault on the person. So I'm wondering it's a rough question in my head.
Well, let me say this, Jordan. So I think, I think like a lot of people, what you're referencing, I think what you're perceiving is an increasing coarseness in speech. And, one only has to go on Twitter to see the way that any attempt to present a rational argument on Twitter is meant by a barrage of, what am I trying to say? Foul-mouthed responses, just calling you an idiot and insulting and all this kind of stuff that is can be very off-putting to people. The only thing I would say, though, is that while I think our speech has gotten worse, and the way we talk to one another in public has gotten worse in recent years, I think we should remember that it's gotten worse compared to what? I mean, I think worse than when I was young, although even when I was in college in the 70s, people would call folks fascist all the time and so on. But it does ebb and flow a bit in society. If you go back and you look back in 1800, the campaign of 1800 between John Adams and Thomas Jefferson for the presidency, there were some pretty nasty things that were said about the two candidates. And, these are two of like the greatest Americans, the partners in writing the Declaration of Independence and this sort of thing. And the things that were said about another were just awful, were horrible. They talked about how Jefferson was going to prostitute your daughters and you'd burn your Bibles and this sort of thing. And Adams was called something like a hermaphroditic character who lacks the firmness of a man and the sensibilities of a woman, something like that. I mean, I have that quote exactly right. So it does ebb and flow, and our founders were not strangers to some pretty tough partisan language. So to me, I think the First Amendment was intended to say, yeah, we're going to tolerate that again, because what's the alternative? The alternative is putting someone from government in there and giving them the power to say, nope, that goes too far. Oh, this is okay. And we know from experience that people will tend to abuse that power. They may not even abuse it because they're bad people. They may just abuse it because, the folks I agree with, it seems to me that their argument's fair. And the people I disagree with, they're being outrageous, and calling people names like that. So we don't want to give government that power. So we tend to be willing to tolerate that.
If there's any,
Yeah.
You can finish.
Oh, I was just say, having said that, I do think it would be better if we would all learn to tone the rhetoric down a bit.
Just one more quick question before we go to the next panelist. Do you know of any times that the founders may have written explicitly of like the philosophical underpinnings of putting the speech first, and possibly of this concept of the word and the logos, being that they all would have been very familiar with the tie together of really the Western civilization being tied to this idea of the logos of logic and the word?
I can't pull up things for you just from memory, unfortunately, but certainly I think that was true. I think you do find that in the writings of Adams. Jefferson was a little bit more polemicist than Adams, but he has a lot of good pithy language as a result, talking about the general importance of free speech to knowledge and to learning. Indeed, I would put the quote I gave at the beginning as being generally in that. He says, this is the only way that we can really get to know the truth. So I do think the founders had it there, but unfortunately, I'm not going to be able here off the top of my head to point you all to something.
Thank you. All right. I believe we can go to our very
Okay.
first time panelist here.
Yashica, would you like to ask a few questions?
Yes. So first off, I wanted to thank everybody for watching. It's great to see other people wanting to learn about the Constitution. We don't see it enough. So let's go ahead and get started. So Professor Smith, since this is the very first ever amendment in the Bill of Rights, I was just wondering, why do you think that they made sure to guarantee these specific rights under the very first amendment?
Well, that's a good question. There's a couple of interesting parts. One is that this wasn't necessarily intended to be the First Amendment. It just kind of ended up that way. And in fact, there were a couple of amendments that were not passed. So sometimes we make a little too much of that symbolism, although it is a pretty neat symbolism, as you point out. Why these particular rights? Again, I think they often go to experience. I mentioned, for example, the issue of William Penn being silenced. They thought that the right to petition for redress of grievances was important in and of itself. It was something folks did. They thought, in Penn's case, the right to freedom of assembly was important. By the way, just a little side trivia. The person who, Madison is often called the author of the Bill of Rights, and he was probably the prime mover. But the man who may have done more than anyone to assure that the freedom of assembly got in was Elbridge Gerry, who is known almost entirely today solely for gerrymandering. But he was, which I just always, I find kind of amusing, because here was a man who was vice president of the United States, governor of Massachusetts, a delegate to the Constitutional Convention, where he was very influential, signer of the Declaration of Independence. And all anybody remembers him for is gerrymandering. But he largely was, as much as Madison, responsible for giving us the freedom of assembly. So anyway, that was one, they picked because they saw the way that the king's governors could break up assemblies, and that kept people from not just organizing to form a revolt, so to speak, but organizing to speak and to talk. And in those days, you really, even more than today, had to assemble. I think they saw the freedom of the speech of the press in much the same way that in England, there were laws that allowed the government to keep things from being published. And I think they understood that speaking was very important, but if you really wanted to reach an audience, you had to publish, and get it out there, because words, they go into the air and they're gone, so they wanted that right to publish, and that was very specific and very well thought of. And again, I point out that all of these things were many of these had appeared in state constitutions. Some of them, did have roots back in the English common law, the English Declaration of Rights of 1689, the Magna Carta. So they kind of had experience with these and knew what they wanted, and they were certainly responding to some of the immediate challenges, some of the immediate complaints they had about the king that led to the revolution and the period after. But they were also, I think, keenly thoughtful about what would make for good government and what was necessary for self-government. Jefferson, who hated the newspapers and so on, always said, though, that he'd rather have, freedom of the press, freedom to publish, than have democratic elections. They felt that was really vital to a self-governing people. So they were well thought out in coming up with these four kind of speech rights, which, as I pointed out, are all kind of interlocking, related, and they support one another and build up one another.
Yeah, so even you mentioned this earlier, that these four rights are kind of similar in a way, but they're also different in their own ways. So why do you think that the founding fathers grouped all of them under one amendment?
Maybe because, as you say, they were all related. They're mutually reinforcing. I don't think they viewed them, again, today, meaning we, the public generally, but even up to the Supreme Court, tend to kind of lump them all together and always call them freedom of speech. And certainly they're closely related. And I think that's probably why they're all under one amendment. But I do think that that at the same time, the framers understood them to be, again, mutually supporting, slightly different and mutually supporting. I think sometimes it's good to remember that, because if we don't, we can kind of start to be led astray. Like when some people begin to say, well, the right to freedom of the press is just if you work for the Washington Post. No, it's not. We all have that right to publish.
Wonderful. And freedom of speech is a big topic that most people refer to when they talk about the First Amendment. So in your opinion, why did the founding fathers guarantee complete freedom of speech and instead of restricting, vile or unpatriotic language? And why did they completely guarantee full freedom of speech?
Yeah, that's a great question, because as I've been kind of waiting for this to be pointed out here or challenged, right? As most of us know, within a few years of passing the Bill of Rights, Congress enacted the Alien and Sedition Acts. And the sedition part of that largely did a lot to try to limit people's ability to criticize the government. There are a number of reasons for that. One reason is that some people at the time viewed the First Amendment really as only going that you did have that right to publish or speak. In other words, the government couldn't stop you from doing it, but once you did, you could, quote, be held accountable in today's language. That position was not held by all, and of course, ultimately turned out to be the losing position. And I think that even within a few years of the Alien and Sedition Acts, I think most people viewed those as something of a black mark on those who supported them, and a black mark in American history at the time. So it's slipping my mind sort of how you frame the original question, but freedom of speech has always been controversial. It's always been something that we have to fight for, and it's remarkable that even many people who signed or voted for that original Bill of Rights, signed that original Constitution, voted for that original Bill of Rights, just a few years later voted for the Alien and Sedition Acts. And maybe that's one reason why we've written them into the Constitution, to remind us that when we get all passionate, we still can't do these things. That's when we make that's when we infringe on people's rights, is when political passion gets the best of us. And the late 1790s were a very, very passionate time. And I would say, in defense of the people who sponsored those acts, the idea of a democratic government like ours was new. I mean, the idea that you could criticize government without being in revolt was really new. So I don't think that's a defense in the sense of saying they were right, but it may help us understand a little bit why they made that error.
So as you said, back then it was a very passionate time, and this idea of being able to revolt against the government was a brand new concept. So, that it takes a lot of maturity, I guess, as the founding fathers to create an amendment that allows complete, freedom for being able to revolt against the government. So what do you think them passing this amendment reveals about the founding fathers?
Well, I think it more than anything reveals their deep distrust of government. Madison famously wrote that if men were angels, we wouldn't need government, and if angels and we wouldn't need people to control government. And he says, we have to control government. People will naturally tend to abuse power, sometimes because they're venal or corrupt, but sometimes just because we're human, and it's easy to mistake our own self-interest with the interest of everybody else, or with what's clearly sort of objectively right. And I think they knew that. I think we were very fortunate to have some people who were very smart, very committed to freedom, and were able to work on these things in an atmosphere in which they had some time to focus. Maybe they were lucky that they didn't have Twitter and so on, but it gave them time to focus and think about, how do we guarantee that this republic can go forward? And I think one thing they recognized was that people simply have to be able to speak, and thought about then again, back to the four kind of elements of the First Amendment here. How do we enshrine that?
And do you think that the founding fathers would have thought that maybe this amendment would have been used for such a variety of purposes, for vile language and for extremely patriotic language?
Well, yeah, I'm not sure they would have thought of, for example, topless dancing as a First Amendment protected activity, or some of the things that we have protected under the First Amendment. And what I just say there is we go back to the idea that when faced with specific First Amendment claims, we've typically tend to err on the side of allowing the speech to go forward. Not again, even speech we think has very little redeeming value, because to go in the other direction simply allows us to start chipping away at the speech that we really do want to protect. So we're willing to protect the negative speech, at least some negative speech at the margins, in order to make sure that the core good speech is not eroded by people claiming that various things, that it's bad, that it's disinformation and it's bad, or it's hate speech and it's bad, something.
Thank you so much, Professor Smith. I'd like to hand it over to Ms. Gillespie.
Thank you.
Well, thank you, Yashica. Great questions. And your question about the purpose of the First Amendment, it kind of was in line with a question that John Chambers was asking. John Chambers said that he likes to always start with what the purpose was of the Bill of Rights. And he said, he's always explained it as a mechanism to keep the government under the control of the people, but lately come to think of it as a mechanism to ensure that there will be a multiplicity of what Madison called factions to counterbalance each other. And is there anything that you'd like to add, Professor Smith, with your thoughts on the purpose of the First Amendment?
Well, I don't think that those two things are entirely contradictory. I think Madison's notion of factions, was that you want it to protect or prevent a faction from capturing government. So to the extent the First Amendment helps to do that by assuring that there's a multiplicity of voices, it's probably in the spirit of the First Amendment. Madison wrote about in his famous 10th Federalist on factions and so on. But I actually tend to agree with Mr. Chambers' fundamental premise as well, that really what we're trying to do is make sure that people are in a position where they can govern themselves, engage in self-government, and I guess I'll leave it at that.
Well, no, that's great. And, that's one of the things that we teach when we go into schools with Constituting America is we spend quite a bit of time with students on the First Amendment. And we actually teach them to learn their rights in the First Amendment with the acronym RAPS, religion, assembly, petition, press, and speech. And we walk them through, we have them all think about something that they might want to change in their community or within the government. And then we walk through with them how they would use each of those First Amendment rights in order to make that change. Starting with petition, where they actually put their thoughts into writing, and then speech, where they would begin to have an assembly, as you talked about, and calling the press so they can come and cover the assembly, and kids really kind of start to get it that way. And that actually leads into John Chambers' next comment, where he said the First Amendment has been called a river of rights, each one leading to the next. And he was wondering if you had any comment on that.
Only I'll say that again, I think we should view the Constitution in that sense sort of holistically, that it is a document that I believe is intended to promote freedom, and that the provisions are, to a large extent, mutually supportive of one another. And not to deviate, because I go off on a 20-minute lecture about like the 9th and 10th Amendments, and I don't want to do that. So I just limit it back to what I've said. Like, even if you look just within the First Amendment, those 4 rights that we tend to lump together as freedom of speech, press, petition, and assembly. And by the way, I like that RAPS thing. I'll have to remember that. That'll make it easier for me. But we put those 4 rights together. They're intended to be mutually reinforcing. They're intended to support one another. And if I'm understanding Mr. Chambers' point correctly, it's just a way of, another way of thinking about that same thing. These are not a bunch of isolated little islands of liberty or something. They're all part of a big document that's intended to assure freedom and self-government.
Definitely. And now Sandy Thatcher asked about a specific court case. He says Tinker versus Des Moines School District 1969 is the main court case on which free speech of K-12 students has been built. How has the subsequent jurisprudence modified the Tinker decision? And I know we're hitting you out of left field with that. Are you familiar with that?
No, well, I'm familiar with the Tinker decision, but I probably can't say too much about the question, because that's not an area of the First Amendment where I have focused a lot of my own attention. That is the rights of students and so on. Basically, Tinker and some other cases suggest that the famous language is students don't lose their First Amendment protections at the schoolhouse door. And we see echoes of that actually in other areas of First Amendment law, like the ability of public employers to regulate the speech of their employees if that speech might cause people to question whether government was operating properly. So Tinker versus Des Moines kind of says this: the school can put limits on, student speech in certain areas, but it has to be really relevant to the education. It can't just be because it's a disfavored idea. So students have been able to wear armbands as a sign of protest to the war. It's a silent protest, doesn't disrupt class. They've been able to wear jackets with swear words on the back. Again, it's a form of protest. What the courts want to look at is there some reason that the state needs to limit that speech beyond the fact that they may not like the ideas that are being put forth, or may just not want the controversy of having people talking about ideas. And only in those cases can they really limit what students want to say and do.
Well, thank you. And then Victoria asks about social media censorship, which we know is all a big issue, but because private companies control social media, there may be limits to free speech in that realm. But could you speak for just a minute or two on censorship on social media?
Yeah, well, this is perhaps the big First Amendment issue right at the moment. As some folks may be aware, earlier this month, the Fifth Circuit, U.S. Court of Appeals for the Fifth Circuit, upheld a Texas law that limits the ability of social media companies to basically knock people off their platforms due to political views. Earlier, a somewhat similar but different law in Florida had been struck down by the 11th U.S. Court of Appeals. So there's a pretty good chance that that issue is going to go to the Supreme Court. On the other hand, the Supreme Court might let it lay for a bit. And the argument is one that kind of pits a couple different concepts of the First Amendment against one another, and it's sort of divided traditional supporters of the First Amendment. On the one hand, you've got people say, look, these are private entities. They can do what they want on a platform. On the other hand, you've got people who are saying that these entities are necessary for people to participate in modern political life. That it's almost an argument saying it's almost similar to being an African American trying to travel through the South in the 50s. It's not, you don't face certain threats of violence and so on, perhaps, but it's very, very hard to exercise your rights if you can be knocked off these platforms. And as the Fifth Circuit said in its opinion, it says, well, look, these platforms aren't being denied their speech rights. They can say whatever they want. They're not being forced to say what someone else wants them to say. They're just being forced to allow people to use their property to do it. That raises a host of issues under property rights and what's called the common carrier doctrine. So it's really something worth thinking about. And for those of us who've always been skeptical of government regulation, regardless of the sort of constitutional doctrine, you need to be skeptical. How is that going to work out? If we give government this power, can we really trust them with power? Versus what seems to be to many people an immediate problem that we can't trust the private sector with that power. And of course, again, while our First Amendment is aimed at government, private individuals can limit speech too.
Well, thank you. And now you are the founder and chair of the Institute for Free Speech. And we'd love here in our last few minutes together, have you tell us a little bit about what you do at the Institute for Free Speech. And Aubrey, maybe you could bring up their website. And I think we've dropped the website into the chat, and maybe we have not yet, but hopefully we can get that link in there.
Well, it's a pretty simple website. It's the Institute for Free Speech. So if you can remember that name, the website is ifs.org, www.ifs.org. You can also follow the Institute. The Twitter handle is a bit tougher. It's INST, I-N-S-T, Free Speech. Or you can look at my own thread at Kamish Smith on Twitter. But what the Institute for Free Speech does, we were founded to essentially focus on political speech issues. So as my weak answer to the very intelligent Tinker question shows, that's not the area we've really focused on. We focused on things that directly tend to limit people's ability to speak in the political arena, including campaign finance laws that purport to set the government up as a truth arbiter for, quote, lies in campaigns, things that regulate people's ability to put up signs and that sort of thing. In recent times, we've been focused in many cases on situations where government comes in and denies people the use of what are public forums. For example, when school boards refuse to allow their critics to speak during public comment time. School boards aren't required to have public comment time unless state law requires it. But if they have it, they can't just let their friends and allies speak and not let their critics speak. So that's the kind of thing that we do. We focus, like I say, on the right of people to engage in direct political speech when the government attempts to get in the way.
Well, you're doing great work. And I would be remiss if I didn't also mention my good friend, Sue Bradley, who works with you at the Institute for Free Speech. And Sue does a great job, and we encourage everyone to check out your website. Do you want to say it one more time? The Institute.
Yeah, it's www.ifs.org.
Okay,
we've got a copy of it up on the screen. You can see one of the latest things we've done, which is a free speech index. This is a comprehensive index of all the political speech laws in the states, and you can see where your state ranks and where it can be improved and so on.
Oh, that's
great.
Some
of the type of research things we do, and as I point out, we litigate cases as well.
Well, that's really interesting. And Aubrey's scrolling through the states there. Aubrey, why don't you look at Utah? That's your there you
go. Utah 17th.
Okay, very interesting. Well, we thank you so much for your time today. It was a really fascinating show. I know we all learned so much. We thank you for your great work on free speech and for just being with us and all that you contributed to our show. Is there any parting comments that you'd like to make?
I'll just say thank you, Kathy. Thank you, Yashica, Jewel, Jorn. And, speech is good. Speech is a good thing. Sometimes people will say things that hurt, but boy, it's a lot better if we can speak than if we can't.
Well, thank you. And Yashica, would you like to say goodbye?
Yes, I'd like to thank you all again for letting me on the show. It was so interesting talking to Professor Smith about, all the different components about the First Amendment and hearing the questions that Jorn and Jewel had. So thank you, everybody.
Oh, we loved having you. We're so glad you could be with us. And Jewel and Jorn?
Yeah, great to have you. And thank you also to Mr. Smith.
Yeah, another great show.
Thank you. And Aubrey, I don't want to leave you out.
Yeah, we're glad that you could all be with us, and we hope that you'll join us again next week at the same time. So 2 p.m. Eastern next Tuesday.
Definitely. We'll be talking about freedom of religion with Professor Chris Burkett from the Ashbrook Center. So thank y'all so much, and we will see you next week.